Arthur is headed to his first court hearing for temporary orders. He already has a protective order that has been slapped on him, and he has not been allowed to see his children for 7 months. Watch as Arthur is forced to teach his attorney and his judge about his rights.
I want you to file the 2 protection motions that I gave to you. Arthur, we have gone over this already. I think that you should wait on that. Take small steps in this process. This is a very delicate situation you are in. Why am I in a delicate situation? How did it happen when I didn't do anything wrong? And I have an attorney you. How could it be bad for me for you to protect my rights? Just trust me on this, Arthur. Let me handle this. You hired me because I'm the one trained in the law, so let me do my job. Is this how you see your job? As just a job to guide a parent through the process of being screwed by the government? Here, Arthur, just let me screw you over quietly. I do not agree with your strategy. I want you to present these motions to the judge and demand that the court hear argument on these motions before any more trials. Look, Attorney Wayne, I hired you to protect my child and my rights. I did not hire you to hold my hand while they screw me and my child out of our rights and destroy our relationship. Show me what you have. I have these 2 motions. I want you to file them. That is an equal protection motion and a due process protection motion. And how do you suppose that I explained to the judge today that he should hear these motions before making temporary orders? These temporary orders are needed, Arthur, so that your child is protected. That's where you and the judge are getting this all wrong. Orders are needed, but not the kind the court thinks. My soon-to-be ex-wife and I protect our children, and I need you to protect my rights to do the equal to her. Go on. The court has not afforded constitutionally adequate procedural protections. I want you to use your legal training to get the court to hear these motions. I want you to tell the court that justice cannot be served today because the court has not determined what procedural protections they will use according to the fundamental rights at issue. The Constitution demands that this court presume me to be fit and to presume that I am acting in my child's best interest and to recognize that before this court can overcome these presumptions and make a best interest determination over my objections, this court must affirmatively show on the record its constitutional authority to act. Article 6 of the Federal Constitution mandates that these protections be afforded any state statute to the contrary notwithstanding. So you are wanting to challenge the statutes then? That has to be done with the legislator. This is procedural. As you read in the DOJ letter, the court decides the proper constitutional procedure to be used. I am asking the court to determine the requirements before they apply those statutes when fundamental rights are at issue. And I would like to go over some objections that I would like you to use as necessary. What would those be? There are 3 more actually. The first one was arguing to the court that justice could not be served today unless they heard these motions first. That we discussed earlier. The second one is an objection to jurisdiction. Not the kind of jurisdiction objection you are probably used to using. We are not used to using any of this actually. You do it in every criminal case. You know very well how to do this. Objection: lack of jurisdiction goes like this. In relation to fundamental rights, this court has not yet established its constitutional authority to act in this case today because it has not determined on the record what rights are in question and has not proven a compelling state interest. This court is not authorized to interfere, reduce, restrict, or unduly burden these fundamental rights. Care, custody, control, and possession of my child are protected fundamental rights. The free association right of me and my child to live together as a family and share the intimacies of daily interaction is a First Amendment protected right. My earnings are my property and they are protected by the 4th and 14th Amendments. The 4th Amendment specifically provides additional procedural protections for property that this court has not met. You are also wanting to challenge the court's authority in awarding child support. Yes. The court is not going to want to hear that. You will be seen as not wanting to support your child. That is why I'm asking you to use your legal training to protect me. The court has it all wrong there too. They are supposed to presume that I support my child until it has been proven that I have failed to support my child to the same basic minimums that every married parent is required. The third objection is an abuse of discretion objection. The objection goes like this. Given the substantive rights at issue, protected by the First, Fourth, and 14th Amendments, this court has failed to provide proper procedural constitutionally adequate protections for those rights. Until the court does so, this court lacks any constitutional authority to invade a fundamental right. Do you have any more? Yes. One more way. This one you file in writing, as in motion, to object to the court if they refuse to hear these motions. You can find an objection on the same website that I got all of this information, motions, and argument. What website is that? www.fixedfamilycourts.com/motions. The specific wording that I'm using in these objections is important because it comes from federal appellate court cases and United States Supreme Court cases. If this judge knows anything, he should recognize this language, as I am sure you do. I still do not think that it is a good idea for you to do things this way. I do not think you understand how things work and how the law works. If you are not going to protect my rights, Wayne, then what am I paying you for? There is really nothing else to understand. I understand that I paid you thousands of dollars so that you could hold my hand while my child and I get screwed, while you pat me on the back and tell me that you did your best. The judge has arrived. I will do my best, Arthur, but no guarantees. I cannot believe this. I just cannot believe that attorneys do not know this stuff. What am I going to do if he does not present those motions?
Arthur is stuck in a dilemma now, where he will be forced to represent himself if his attorney does not fight the status quo, or he can cross his fingers and hope that the court does not impose more financial burdens and stress on him than he can handle. Arthur faces punishment as severe as jail if he cannot pay some of the bills that the court creates. The court can order Arthur to pay for an attorney for his child, to pay for custody evaluations, to pay for counseling, child support, alimony, his ex's attorney, and the list goes on. Without the rights arguments, Arthur could face total devastation and bankruptcy. If Arthur is forced to represent himself, he also faces so many disadvantages. The legal profession keeps a lot of the process secret. Arthur will not have the same access as the attorneys to the judge, the court coordinator, and other things. The only thing that protects Arthur are his rights. Without these, he will be powerless.
If my lawyer is not going to present these motions, I am going to have to do it myself. There are support groups that I can go to at Fixed Family Courts where I can practice and learn more. www.fixedfamilycourts.com/webinars